In this installment of Washington Legal Foundation's LegallyBrief.com, Stephen Grafman, a partner with the law firm Sharp & Associates here in Washington, D.C., and a former Assistant United States Attorney, will talk about how the government uses the so-called Perp walk to inflame public opinion in white-collar criminal enforcement situations.
Just when we thought the Justice Department might opt to abide the fundamental principle that one is innocent until proven guilty, the perp or perpetrator walk rears its ugly head again. This stunt is a choreographed photo op through which the government provides an advance notice of an arrest to ensure the media is on site for a handcuffed walk to jail by the alleged. Such a spectacle occurred recently with the arrest of two Bear Stearns hedge funds executives. These infamous walks quickly made the front page of the Wall Street Journal and other respected media outlets, showing both individuals convicted of nothing, yet for all to see being escorted by stern-faced government agents displaying capture of the supposed bad guys. Hardly, though, were these executives about to flee. Surely they would have self-reported, all without a Roman circus atmospherics that the government generated. The media, of course, was not present to witness these Bear Stearns executives' prompt release on bond. Obviously, the government had no interest in alerting the media that these individuals would be leaving the courthouse. The discriminatory manner in which the government resorts to this charade is appalling. Why, for example, were Messrs. Skilling and Lay of Enron notoriety subjected to a perp walk while Martha Stewart was not? And why were these Bear Stearns executives subjected to a perp walk with Senator Stevens spared this ignoble spectacle only recently? In short, the government uses the perp walk when it believes it's advantageous to do so, and only then. Why does this conduct continue? In the Bear Stearns case, surely to assuage public opinion, at least in part, about the housing subprime mortgage collapse. Through such staged spectacles, public opinion pictorially can be spun to the point that some may even believe the crisis du jour is at an end with these arrests. Of course, this is sheer nonsense. The Enron era provides a further analogy. There, too, there was a need to placate the angst of the American public. As the government well knows, footage of such spectacles is not relegated to some digital trash pile. These pictorial suggestions of guilt are replayed by the media every time judicial activity occurs, and that, of course, sometimes is over months or even years. Continuation of this distasteful process, moreover, diminishes the credibility of those obligated to do more than seek convictions, that is, to their higher obligation to see justice is done. Guilt or innocence is not the issue as pretrial cameras roll. An accused is entitled to his or her day in court without public opinion inflamed by pre-arrest government showstoppers, which of course can also have a significant impact on a future jury panel. News of an acquittal rarely matches sensational pre-arrest hype. The most vivid illustration, former Labor Secretary Ray Donovan's acquittal of fraud charges, after which he publicly asked, "Which office do I go to get my good name back?" Certainly it was not to the prosecutor's office. Moreover, one simply cannot unring a bell. Should the perp walk Bear Stearns executives be acquitted, and don't forget they are presumed innocent, the government no doubt will issue a bland statement which in effect says that they respect the jury verdict while ignoring its own disrespect for the presumption of innocence. In the final analysis, if the government has a case, let it be made in the courtroom and not through a back door that leads through the press room.